This is Justice, History, and the Law. Lectures, discussions, and interviews from the Robert H. Jackson Center in Jamestown, New York. June 27th, 2003. Former federal judge and special prosecutor Kenneth Starr speaks with Jackson Center President Gregory Peterson about the legacy of Robert H. Jackson. Following that conversation, Judge Michael Keasler addresses a luncheon at the Athenaeum Hotel in Chautauqua Institution.
Well, Justice Jackson was viewed, and I can think continues to be viewed, as one of the most talented members to sit on the court in this last century, in the 20th century. And that's all the more remarkable because his service was so short-lived due to his premature death. But he was known not simply for the elegance of his writing, which is legendary, spectacular writer, but also because he was so powerfully independent and really stood for the ideal of judicial independence. One of my favorite aspects of Justice Jackson's work is the fact that he, as a justice, took a different position than he had taken as the Attorney General of the United States and advising President Roosevelt. He issued a legal opinion as the Attorney General to the effect that the Lend-Lease arrangement with Great Britain was lawful under the constitutional laws of the United States. So then years later, he finds himself on the court, and that very opinion was being cited as a principal authority for President Truman's taking over the steel mills and directing the Secretary of Commerce, Mr. Sawyer, to take them over. And his response at the oral argument was just marvelous, that it was in his elegant manner, but he made the point. I was an advocate then, I'm a judge now. And he did not take that position as a judge that he had taken as a lawyer, and as indeed not simply a lawyer, but as the Attorney General.
And you also yesterday in your speech talked about Nixon, you talked about Gore, you talked about even the Magna Carta, and how the rule of law and how important that is, rule of law, in our system. Even if you don't agree, you obey. You made that point very well yesterday, and I couldn't help but think of the steel seizure case as being another one of those examples where, despite it all, and I'm sure President Truman was not a happy camper. Does that case and that whole presidential powers rule that came from that, did you see that as law today?
Yes. I think it was Justice Jackson's concurring opinion in Youngstown that gave the most analytically impressive, call it taxonomy, of presidential power. And it continues to be viewed as the great source of authority as to where in our constitutional system does the president's power come from, what are the different dimensions of that power in the context of not simply foreign policy, but the use of military force and the like. And I don't want to say that it's the last word in terms of the analysis, but it's one of those principal sources of law that people go to in terms of what is the nature and structure of our government, especially with respect to the presidency. And that's another thing about Justice Jackson. Not only did he serve for such a short time, but he, in that short time, was able, due to the exigencies, the case law, and so forth, to articulate some of the really enduring lessons on both the structure of our government and then on individual rights, individual liberties. He was just impressively right, in my view, virtually all the time. I mean, that's one person's opinion. But right in the sense that people just keep going back to his articulation has abled his ability to, with the English language, to really capture profound ideas in our constitutional system and in a representative democracy in a way that was beautifully, simply, eloquently stated. There's a Lincoln-like quality to his ability to articulate.
You talked about today individual rights, and you talked about the pledge case, the
Right.
flag salute case, and Barnett. How does that particular case, the Barnett case, fit into the case that you currently have argued for the Supreme Court? I'm not sure where the status is.
Yes, the Pledge of Allegiance case is going to be reviewed by the court in some manner or other. It has not accepted review, but the Solicitor General's office has asked the court to either summarily reverse the case or to have it fully briefed and argued on the merits. So it's a case the court can't ignore. You can't have the Pledge of Allegiance being declared unconstitutional in one part of the United States. So it is almost a given that the court will have to do something with the case. But Barnett was the West Virginia case that, again, gave voice to one of the most important parts of our constitutional tradition, which is freedom of conscience. Justice Jackson was able boldly to guide the court intellectually to overrule a fairly recent opinion coming out of Pennsylvania involving the same set of facts, but with a different result. A very impressive opinion authored by Justice Frankfurter to the effect that the state could require children to engage in patriotic exercises on pains of expulsion from the school if they did not, and even criminal prosecution of the parents if then they didn't come to school because they'd been expelled because they wouldn't participate in the flag salute ceremony or the Pledge of Allegiance. And Justice Jackson in Barnett wrote, I think, some of the most beautiful and powerful language in the judicial literature about what this country is all about, which is tolerance of ideas, tolerance of the individual conscience, that the forces of the state have to respect the ability of the individual dissenter, even if the view is seen as very idiosyncratic, cranky, or the views of a crank, but that those views have to be respected as part of the human dignity. And he called it the freedom of the mind, which is a great way of expressing a lot of First Amendment values and concerns.
Is there a judicial philosophy that one can really discern from Justice Jackson, or is he able to be categorized?
He shouldn't be pigeonholed, but one can see a judicial philosophy at work. He certainly believed in the idea of the representative democratic process, and the judges should be cautious in stepping in and, shall I say, throwing their weight around, preventing Congress and the President from determining what public policies they thought were best. He, of course, had served in the Justice Department at a time when the Supreme Court was undergoing and then underwent a very significant change in attitude and philosophy, whereas in the early 30s, during the early days of the Roosevelt administration, virtually anything that the Roosevelt administration did that made it up to the Supreme Court got tossed out by the angry old men. And then President Roosevelt came up with the ill-fated court packing plan. That failed. But in the meantime, there was a change in membership in the court, but also I think just a growing sense that the court seemed to be going too far, declaring this act unconstitutional, that statute unconstitutional. And Justice Jackson was, of course, an advocate at the time, Solicitor General, Attorney General. So he saw up close and personal during those years the excesses of judicial power. So he became a justice then in 41. The court had changed its philosophy, but the change was very, very recent. So I think he felt that very keenly, that the court should play an important role, but it should be quite respectful of the democratic process. At the same time, in case after case, he showed how important he saw individual rights, individual liberties. One of the great legacies of Robert Jackson was his dissenting opinion in the Korematsu case, the Japanese internment case, where again he got it absolutely right, and going against the grain of the time, the current of the age, which is we're at war, so we're going to have to take these extraordinary steps in the interest of national security. His view was Fred Korematsu is a United States citizen. You can't treat him this way. You can't just summarily take him away and forcibly intern him at some camp in California away from his home and livelihood and so forth. That's not our nation. So he had great practical wisdom. You know, I note that he was very proud of being a country lawyer, and he wasn't burdened with too much education. His education was earned the old-fashioned way, and I think that may have aided the clarity of his thinking, as well as perhaps the beauty of his expression. He didn't take creative writing courses, he just read great writing.
We've had, as I mentioned on the way down, Fred Korematsu did come here. He was saluting, if you will, Justice Jackson, which was an honor for us, because there is that sense of individuals behind these lawsuits. This April, the two daughters of Oliver Brown are coming on virtually the 50th anniversary of Brown versus Board of Education, of which Jackson was a part. Yesterday you talked about how there were really two cases which the Supreme Court, either culture affected the Supreme Court or the Supreme Court affected the culture, and you cited Brown versus Board of Education. For the benefit of those who may be listening to this as maybe a prelude to Brown versus Board, could you talk a little bit more about that particular case and how it's really affected?
Well, it was a great act in judicial statesmanship, and credit has to be given, and it has been given, rightly so, to Chief Justice Warren for his leadership in that effort, not only to overturn the half-century-old case, Plessy against Ferguson, which essentially ratified Jim Crow, ratified the idea that there could be separate facilities for African Americans, for black school children, as long as they were, quote, equal. The separate but equal, of course, was hollow and empty. But that was the theory. Give them equal facilities and treatment, but it'll just be separate, and everything will be okay. It's a terrible rule, one of which we should be terribly ashamed. And the upshot was that we had a half century of separate but equal, that the law permitted, our Constitution as interpreted by the Supreme Court, permitted this sort of terrible regime and deprivation of human dignity. And Justice Jackson was a very integral part of the most certainly important case of that half century of saying, no, you have to stop this line drawing by race and to allow all the school children to be educated together. And of course there was a broader message in that, but that was a very important foundational principle that had just been ignored by the Supreme Court and rejected by the Supreme Court for those many years. And I think that changed the way we began thinking as a society. It no longer was legitimate to say there should be segregated members, of the bar, segregated facilities as well as segregated schools. I must say, in tribute to others, Brown versus Board of Education did not just spring full-blown from the head of Zeus. President Truman issued an executive order desegregating the armed forces. There were other steps in that direction. But the power of Brown versus Board of Education in establishing the equality principle and the seriousness of line drawing by race is difficult to exaggerate, and Justice Jackson was a key part of that.
One of the things that's, doing some research, Justice Jackson sort of one of the kind of the last guys to sign on, if you will, for that unanimous court. He was struggling with, one sense, agreeing that morally there was no justification for the continuation, but whether or not this was really a decision for the states or whether it was a federal decision, and which led a little bit to the Rehnquist memo, which has gotten a lot of play, etc. And just totally aside, the attorney for the plaintiff, Plessy, or whoever the losing party was from Mayville, New York, a guy named Albion Torget.
My goodness.
And then, 50-some years later, so he was on the losing side. His position was, of course, ratified by the court, the Warren Court, which one of the members of the court was another guy from Chautauqua County. So we had both ends of, I'll show you this later, but we found this in a book sale, a book by Albion Torget, which inside was inscribed by Robert Jackson.
Oh my goodness.
Jackson owned the book of Albion Torget, which kind of ties in both particular issue.
Well, I would just say that Justice Jackson was a great student. Again, not formally educated, and famously so, but nonetheless he was a great student, self-taught. Others who have served with great and renowned distinction, Hugo Black, Justice Jackson and Hugo Black didn't agree all the time, but nonetheless they shared the characteristic of having educated themselves, in effect, in the tradition of Abraham Lincoln. So it's a remarkable thing that someone could do this. But the point I was going to make is his education led him to really respect the important principle of structure and architecture of the Constitution, so that he would worry not about the morality and the like with respect to segregation and desegregation, but he would worry about the structural principle. The federal government should not be permitted to segregate, but the states, I have to worry about that. Doesn't follow so naturally. And I'm fearful that we as a people are tending not to take the Jacksonian lesson to heart that structure counts. One of the things that the founding generation felt strongly about is that the protection for liberty of the American people lay in large part in the structure of government and the architecture of government. And we had to make sure the architecture was sound. Build a sound building. Don't have a building with a faulty foundation or with huge structural flaws of another kind, because the building will be defective and the building could collapse. And that was the view of the founding generation. They studied the architecture of government. These days, people say, well, there's a problem, just go out there and solve it. And I guess the national government should be able to do that. And Jackson, to his credit, even as someone who believed in a strong and robust central government, was always worried. He worried not in the Hamlet-like sense, but worried in the sense of, I want to get the right answer.
Well, what's the legacy of Robert Jackson?
One of unselfish service, including his willingness to be called away from service on the court, controversially so, to serve with renown as chief prosecutor in Nuremberg, and to develop in very short order and to present persuasively a case of, shall I say, universal significance. And it simply doesn't do justice to his performance to say it was of historic interest. It was of mega-historic interest. The idea that individuals should be called to account, the senior leaders of the regime should be called to account for their war crimes, very important, and led quite then overtly to important declarations like the Universal Declaration of Human Rights. That episode that he was such an instrumental part of just illuminated the path in terms of human rights now for perhaps centuries to come. It's as if we've all agreed, now it's a question of, we have a good design, Now we need to implement, and he was at the foundation of that. And at the same time, he, during his relatively short life period on the court, became one of the most respected justices ever to sit on the court. I think universally agreed to be one of the great justices to serve, but certainly one of the great justices of the last century.
You are listening to Justice, History, and the Law, lectures and interviews from the Robert H. Jackson Center in Jamestown, New York. Next, Judge Michael Keasler.
Now, a little bit about how the fact that Judge Keasler is here today. Unlike the normal situation, I assume, where we hunt out speakers, Judge Keasler called me and said he'd heard about us through a conversation he had with Eugene Gerhardt. Eugene Gerhardt is currently the only biographer of Robert Jackson, having written a book called America's Advocate in 1958. Judge Keasler, doing his research, tracked Gene Gerhardt down. Gene Gerhardt, at age 90, was our first speaker at the Robert Jackson Center. And, in fact, his book, America's Advocate, which was supplemented in 1961 by the Green Book, of which I have put someplace, is going to be reprinted and available next year. Long story short, Judge Keasler got on the internet and found out that we were having this event with the clerks and said, gee, I want to be part of this. I want to be a spectator. I want to enjoy the fact that these clerks are gathering together because I'm a big fan of Justice Robert Jackson. I then carried on our conversation and learned a lot about Judge Keasler. Judge Keasler is a judge of the Texas Court of Criminal Appeals, the state court of last resort in criminal cases. He received his undergraduate and law degrees from the University of Texas at Austin. In 1981, he was appointed judge of the District Court in Dallas, a general jurisdiction trial court, where he served for over 17 years. Judge Keasler served as chair of the State Bar Judicial Section, the Texas Center for the Judiciary Board of Directors, the ABA State Trial Judges Ethics Committee, the Dallas County Criminal District Judges, the Dallas County Juvenile Board, and the Dallas Bar Association Criminal Law Section. He's also served as presiding local administrative judge and dean of the Texas College of Advanced Judicial Studies. However, this is where it caught my attention. He mentioned the fact that he was the 2002 Robert H. Jackson lecturer. I said, whoa, now you've got my attention. He had been selected to be the Robert H. Jackson lecturer at the National Judicial College in Nevada. Then I went on the internet. I thought, man, if he can get on the internet, so can I. And I learned more, that this Robert H. Jackson lectureship, created in 1967 by Judge Tom Clark, a name we've heard earlier today. And he was one of the first lecturers, and also other selected lecturers included Byron White, Sandra Day O'Connor, Anthony Kennedy, then Vice President George Bush, and it goes on and on, kind of the who's who of the American judiciary. Now, I said, I got to reverse the roles here. If he's coming, we need him. And so with that, I asked if he would share with us parts of the speech he gave in April of 2002 at the National Judicial College as the Robert H. Jackson lecturer. So we have a bonus in our midst, and I'm pleased to introduce the Honorable Michael E. Keasler.
Well, thank you, Greg. When Greg asked me to speak this evening, I was really both touched and honored. I thought of all the distinguished people here who either knew Justice Jackson or were related to him or had been exposed to him in this town all these years, and I wondered what I could possibly say. But it's really an extreme honor for me. when he told me, I was kind of reminded of what Jack Benny said one time when he received an honor. He said, "I really don't deserve this, but I have arthritis, and I don't deserve that either." But I have pictures of 5 personal heroes hanging in my chambers at the court. These are 5 individuals who personify excellence. They include Abraham Lincoln, Lou Gehrig, my constitutional law professor Charles Allen Wright, legendary District Attorney Henry Wade of Roe v. Wade fame, and the prosecutor of Jack Ruby, District Attorney there for 36 years, and Robert H. Jackson. To me, Robert Jackson represents the very best that the bench and bar have to offer. And I'm telling you a lot. I'm reprising my Jackson lecture, but a lot of this I'm sure that you all know. He was born in Pennsylvania in 1892, but moved here to Chautauqua County when he was 5 years old, graduated from high school in 1910, and took a 1-year graduate course at Jamestown High School. Right after that, started a 3-year clerkship in a law office, and in the next year, 1911, he entered Albany Law School and finished the 2-year course in 1 year, was licensed to practice. Well, he came back to Jamestown, finished his clerkship, took the New York bar examination, and was admitted to practice in 1913 at the age of 21. So that's a great achievement just right there. He practiced law in Jamestown over 20 years and was very successful. By all accounts, he was a complete general practitioner. He was tough, brilliant, hardworking. He was a leader of the bar, serving as president of his local bar association, and later as chairman of what later became the ABA House of Delegates. That was while he was still here in Jamestown. A friend later said of him, "Robert Jackson represented the advocate at his best. He possessed the rare combination of a good jury personality and the qualities of a profound lawyer. He knew how to talk persuasively to a jury of Chautauqua County farmers, yet he could argue the points of law involved in the case with great learning and with unanswerable logic, either before the trial judge or an appellate court. He had high standards of craftsmanship as a lawyer. He was thorough and painstaking in preparation." In 1930, while he was still here in Jamestown, Jackson was proposed for membership in the prestigious American Law Institute. In the membership committee meeting, then Chief Judge Cardoza supported his election. When the time came to vote on Jackson, a committee member said, "Who is Jackson? I've never heard of him." Cardoza replied, "You will in time." In 1934, Jackson joined the Roosevelt administration as general counsel for the Internal Revenue Service. Roosevelt successively appointed him Assistant Attorney General in charge of the Department of Justice Tax Division and Attorney General in charge of the Antitrust Division. He performed each assigned task efficiently and professionally, quickly earning the reputation as the administration's best lawyer. In 1938, Roosevelt appointed Jackson Solicitor General, and he performed the job so admirably, Justice Brandeis remarked that he should be Solicitor General for life. In 1940, Roosevelt appointed Jackson Attorney General. One of his colleagues in the Justice Department later said, "As Attorney General, Solicitor General, and Assistant Attorney General, he lost but a single case in the Supreme Court. Against that may be tallied some 27 arguments that he won." In April of that year, Jackson addressed the second annual conference of United States attorneys. He told them, "Nothing better can come out of this meeting of law enforcement officers than a rededication to the spirit of fair play and decency that should animate the federal prosecutor. Your positions are of such independence and importance that while you are being diligent, strict, and vigorous in law enforcement, you can also afford to be just. Although the government technically loses its case, it is really won if justice has been done. The qualities of a good prosecutor are as elusive and as impossible to define as those which mark a gentleman, and those who need to be told would not understand it anyway." A sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power, and the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. On June the 12th, 1941, President Roosevelt appointed Robert Jackson as Associate Justice of the Supreme Court of the United States. He served there until his death in 1954. A leading constitutional scholar summarized his judicial career in these words: "Nature had given him a bright, strong mind. It was one of the best 3 or 4, possibly 5, of the court during his years of service. It was a disciplined mind, self-disciplined, and sharpened by the varied incidents of a general practice. He had attended no college. His engaging style, his easy acquaintance with good literature, he had acquired for himself. Even in his 1 year of law school, his training had been in practical subjects taught by practical men. The assurance and courage that comes from professional mastery, that too he had won for himself. So he became an exemplar of the best virtues we attribute to our tough common law system. He thought in terms of concrete operations. A good judge should feel responsible for the practicality of his judgments. He displayed, too, a constant concern that the court's pronouncement convey to the practitioner a workable rule of conduct. To his fingertips, he retained a feel for private practice. This was the American lawyer at his best, when what he made of himself as an inspiration and a challenge to all who follow his calling." In describing the judicial office, Jackson wrote, "Something happens to a man when he puts on a judicial robe, and I think it ought to. The change is very great and requires psychological change within a man to get into an attitude of deciding other people's controversies instead of waging them. It really calls for quite a changed attitude. Some never make it, and I'm not sure I have." He also wrote, "When we went to law school, or when we went to school, we were told that we were governed by laws, not men. As a result of that, many people think that there is no need to pay any attention to judicial candidates because judges merely apply the law by some mathematical formula, and a good judge and a bad judge all apply the same kind of law. The fact is that the most important part of a judge's work is the exercise of judgment, and that the law in a court is never better than the common sense judgment of the law that is presiding, the judge that is presiding." In his book, The Supreme Court and the American System of Government, Jackson wrote shortly before his death, "My philosophy has been and continues to be that the court cannot and should not try to seize the initiative in shaping the policy of the law, either by constitutional interpretation or by statutory construction. While the line to be drawn between interpretation and legislation is difficult, and numerous dissents turn upon it, there is a limit beyond which the court incurs the just charge of trying to supersede the lawmaking branches. Every justice has been accused of legislating, and everyone has joined in that accusation of others. When the court has gone too far, it has provoked reactions that have set back the cause it is designed to advance and has sometimes called down upon it severe rebuke." Jackson believed strongly in judicial restraint and looked askance at attempts to determine legislative intent. In this respect, he was a precursor of Scalia, Thomas, Easterbrook, and Posner. Listen to his words. Don't they sound familiar? "It is only the words of the bill that have been given presidential approval where that approval is given. It is not to be supposed that in signing a bill, the president endorses the whole congressional record. I should concur in this result more readily if the court could reach it by analysis of the statute instead of by psychoanalysis of Congress. When we decide from legislative history, including statements of witnesses at hearings, what Congress probably had in mind, we must put ourselves in the place of a majority of congressmen and act according to the impression we think this history should have made on them. Not having been a congressman, I am handicapped in that weird endeavor. This process seems to me not interpretation of a statute, but creation of a statute." Jackson's writing style was unique. His colleague Felix Frankfurter said of him, "To an unusual degree in the history of the court, Justice Jackson wrote as he felt. In his case, the style was the man. He wrote as he talked, and he talked as he felt. The fact that his opinions were written talk made them as lively as the liveliness of his talk. He had impish candor, to borrow one of his own phrases. Candor, indeed, was one of his deepest veins. There was nothing stuffy about him, and therefore nothing stuffy about his writing. No man who ever sat on the Supreme Court, it seems to me, mirrored the man in him in his judicial work more completely than did Justice Jackson. His speech breaks through the printed page. He was one of those rare men whose spoken word survives in type. Another friend said that he had a reservoir of learning from which he drew gracefully and effortlessly. But the most marked quality of his judicial and non-judicial writing was not the ability to borrow an apt quotation or to find an idea well expressed by one who had written before him. It was the ability to think brilliantly in original and bold fashion and to express his thoughts in forceful and eloquent English of a style inimitably his own. His writing was pithy and pungent, yet he never sacrificed clarity of thought for a well-turned phrase. He was a master of the paradox, he had a great love of alliteration, and his antithetical statements were gems. Yet his wit never descended to the frivolous. It always added a barb to the telling point. His wit was especially telling when turned upon himself or his court. Examples of his wit abound. In a 1951 ABA Journal article about Supreme Court advocacy, he said, "I used to say that as Attorney General, I made 3 arguments in every case. First came the one I had planned, as I thought logical, coherent, complete. Second was the one actually presented, interrupted, incoherent, disjointed, disappointing. The third was the utterly devastating argument that I thought of after going to bed that night." He went on to say, "On your first appearance before the court, do not waste your time and ours telling us so. We are likely to discover for ourselves that you are a novice, but will think none the less of you for it. Every famous lawyer has had his first day at our bar, and perhaps a sad one. Be respectful, of course, but also be self-respectful, and neither disparage yourselves nor flatter the justices. We think well enough of ourselves already." In the 1953 case of Brown versus Allen, Jackson said, "Reversal by a higher court is not proof that justice is thereby better done. There is no doubt that if there were a super Supreme Court, a substantial proportion of our reversals of state courts would also be reversed. We are not fallible, and we're not final because we're infallible, but we are infallible only because we are final." Jackson's exasperation was quite apparent in the 1947 case of SEC versus Chenery Corporation, when he wrote in dissent that the court's reasoning adds up to this: the commission must be sustained because of its accumulated experience in solving a problem with which it has never before been confronted. I give up. Now I realize fully what Mark Twain meant when he said, "The more you explain it, the more I don't understand it." With charming candor, Jackson freely admitted his mistakes. In Massachusetts versus United States, he wrote, "Under these circumstances, except for any personal humiliation involved in admitting that I do not always understand the opinions of this court, I can see no reason why I should be consciously wrong today because I was unconsciously wrong yesterday." Again, in writing about one of his own Attorney General's opinions that he believes should be overruled, he said in a concurring opinion, "I am entitled to say of that opinion what any discriminating reader must think of it. It was as foggy as the statute the Attorney General was asked to interpret." Then, quoting Lord Westbury, he wrote, "I can only say that I am amazed that a man of my intelligence should have been guilty of giving such an opinion." Professor Charles Allen Wright believed that Justice Jackson's dissent in the 1944 case of Korematsu versus United States was the most eloquent judicial statement ever made describing American democracy. Jackson wrote, "Korematsu was born on our soil of parents born in Japan. The Constitution makes him a citizen of the United States by nativity and a citizen of California by residence. No claim is made that he is not loyal to this country. There is no suggestion that apart from the matter involved here, he is not law-abiding and well-disposed. Korematsu, however, has been convicted of an act not commonly a crime. It consists merely of being present in the state whereof he is a citizen, near the place where he was born, and where all his life he has lived. A citizen's presence in this locality, however, was made a crime only if his parents were of Japanese birth. Had Korematsu been one of four, the others being, say, a German alien enemy, an Italian alien enemy, and a citizen of American-born ancestors convicted of treason but on parole, only Korematsu's presence would have violated the order. The difference between their innocence and his crime would result not from anything he did, said, or thought different than they, but only because he was born of different racial stock. Now, if any fundamental assumption underlies our system, it is that guilt is personal and not inheritable. Even if all of one's antecedents had been convicted of treason, the Constitution prohibits its penalties from being visited upon him. But here is an attempt to make an otherwise innocent act a crime merely because this prisoner is the son of parents as to whom he had no choice and belongs to a race from which there's no way to resign. If Congress, in peacetime legislation, should enact such a criminal law, I should suppose this court would refuse to enforce it. Justice Jackson correctly predicted that if he were to be remembered by posterity, it would be for his writing and for his service as the chief American prosecutor at the Nuremberg trials. As you already know, in 1945 and 1946, at the request of President Truman, Jackson took a leave of absence from the court to serve in that capacity. The major participants all agreed that Jackson was the guiding force behind the organization and implementation of the trials, and that his performance was masterful. In his opening address before the International Military Tribunal, Jackson said, "The privilege of opening the first trial in history for crimes against the peace of the world involves a great responsibility. The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. That four great nations, flushed with victory and stung with injury, stay the hands of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason." In March of 1954, Justice Jackson suffered a heart attack. His doctors told him that if he reduced his work activities, he could live a relatively long life. But he left the hospital on May the 17th and went directly to court so that the entire Supreme Court could be present when Chief Justice Warren announced the unanimous decision in Brown versus Board of Education. He soon returned to his rigorous work schedule. On October the 9th, 1954, a second heart attack killed him. He was 62 years old. In a memorial tribute in the Columbia Law Review, Justice Frankfurter wrote, "Self-reliance, good-humored tolerance, recognition of the other fellow's right to be and to thrive, even though you may not think he's as good as you are, suspicion of authority as well as awareness of its need, disdain of arrogance and self-righteousness, a preference for truculent independence over prudent deference and conformity, these were the feelings that shaped his outlook on life. He liked his kind without being sentimental about it. He was gregarious but shy about intimacies." In the same Columbia Law Review issue, one of his former Justice Department colleagues wrote, "He had a quiet courage which never led to a bellow of defiance, but which permitted him to take in any instance the action he thought best without discernible thought of criticism or personal injury. He was modest in manner, yet supremely confident of himself and his judgment. He had a calm which no crisis could disturb, and standards of honorable conduct which were both rigorous and unshakable." Possibly the best description of Robert H. Jackson is found in his own words, his 1944 tribute to country lawyers in the ABA Journal. "The vanishing country lawyer left his mark on his times, and he was worth knowing. He read law in the commentaries of Blackstone and Kent, and not by the case system. He did not specialize, nor did he pick and choose his clients. He rarely declined service to worthy ones because of inability to pay. Once enlisted for a client, he took his obligations seriously. He insisted on complete control of the litigation. He was no mere hired hand, but he gave every power and resource to the cause. He identified himself with his client's cause, sometimes too fully. He would fight the adverse party and fight his counsel, fight every hostile witness and fight the court, fight public sentiments, fight any obstacle to his client's success. He never quit. He moved for new trials, he appealed, and if he lost out in the end, he joined the client at the tavern in damning the judge, which is the last rite in closing an unsuccessful case, and I have officiated at many. He loved his profession. He had a real sense of dedication to the administration of justice. He held his head high as a lawyer. He rendered and exacted courtesy, honor, and straightforwardness at the bar. He respected the judicial office deeply, demanded the highest standards of competence and disinterestedness and dignity, despised all political use or trifling with judicial power, and had an affectionate regard for every man who fulfilled the exacting prescription of the just judge. The law to him was like a religion, and its practice was more than a means of support, it was a mission. He was not always popular in his community, but he was respected. Unpopular minorities and individuals often found in him their only mediator and advocate. He was too independent to court the populace. He thought of himself as a leader and lawgiver, not a mouthpiece. Often his name was, in a generation or two, forgotten. It was from this brotherhood that America has drawn its statesmen and judges. A free and self-governing republic stands as a monument for the little known and unremembered, as well as for the famous men of our profession. Well, Robert Jackson was a famous man of our profession. Indeed, he was the consummate professional. His splendid example makes me proud to be a lawyer and a judge. In the words of Professor Charles Fairman, he will live in the living law of the Constitution. Thank you.
The Jackson Center is a historical and educational facility dedicated to preserving the legacy of this country lawyer who became Solicitor General, Attorney General, a Justice of the Supreme Court, and served as Chief Prosecutor at the Nuremberg trials of Nazi war criminals following World War II. To learn more about this program, Robert Jackson, the Jackson Center, and upcoming events, the Jackson Center is located at 305 East 4th Street, Jamestown, New York, and found on the web at www.roberthjackson.org or contacted by telephoning 716-483-6646.